are joining us through Facebook Live. We are co-streaming via Facebook Live and Zoom, and we're looking forward to having a great discussion. Today is my distinct pleasure on behalf of the Return to Work Safely Task Force here in the Tri-County area to welcome Kevin Troutman and Lariza Hebert, who are joining us from Fisher and Phillips. They are employment attorneys, and as their tagline says, they are on the front lines of workplace law. So Kevin is a partner and is a very familiar face to those on the Katy Chamber, having been a member and an active board member for a number of years. And then Lariza, I think this is your first time joining us here as one of our events, and we're delighted to have you. Lariza has recently written an article which she's going to share some information from, and I think you're going to find it quite engaging. Please drop your questions into Q&A or chat, and I will share them with our speakers as we go along life's way. So with that, Lariza, why don't you go ahead and share your screen?
Okay, are we ready to proceed, Jeanette?
Yes, we are.
Okay, great. Well, we're happy to be here, excited to confer with the task force again. I had the pleasure of doing this last month, and Lariza has actually joined me a couple of times several times now on various COVID-related and litigation-related webinars. So we're glad to get to talk to this group because you're really focused on some things that are critically important to the overall health and the economic health of the community, and even the psychological health of the community. So we're glad to be a part of it and hope that we can bring some ideas to you that are helpful today. We're going to focus on where some emerging litigation hotspots are as we start to see things change. I don't know whether to call this, one of the terms we've used is beyond the curve, and I guess we're beyond the curve in one respect. We're still dealing with a lot of things, and increasing positive cases in our area and in our state, and so there's still a lot of challenges out there, a lot of things we need to do on the physical health as well as the business health. But we're going to talk about the litigation hotspots and what we see happening out there, and we'll try to keep the broad perspective of everything that's happening, but our focus is going to be on what can you do to protect yourself against legal claims, and what kinds of legal claims are we seeing that are occurring. And we're going to be kind of interactive. We'll take questions along the way, and Lariza and I are both going to talk. Lariza actually wrote an article that I thought was really good, about 6 weeks or so ago, on this topic, and I found it to be very, very instructive as we've moved along. So with that, let's go ahead and move forward a little bit. Here's something that I would say is worth taking a look at when you get a chance. I mentioned the last time I was on that we have tons of free resources on our website in our COVID-19 Resource Center. One of the things that we've added over the last few weeks is this litigation tracker, which shows where litigation related in some way to COVID has happened in the country and where the hotspots are. The darker the color, the more cases that indicates in a particular area. So you see California's been a real hotspot. New Jersey, New York, Florida, and Texas are areas where there have been more lawsuits filed. And overall, since we started this back several weeks ago, there have been about, over 300 now, over 311, I think today. You can get a real-time look at this through our website that you see down at the bottom left. But that number is increasing every day. Plaintiffs' lawyers are eager and looking for ways to bring cases forward based on the pandemic or related in some way to the pandemic. So some of these things are not going to necessarily be new, but they're going to have a new twist to them. And that's part of what we're going to talk about. So you can dig down and really actually get a lot more information than what you see here. You can look at state-specific information and the types of cases filed, as well as where they're filed. So a lot of good information there.
And we're actually at 327. This 311 was from Friday, so in 2 days.
Okay.
On it.
Okay. Yeah, we see that number move regularly. So one of the things that we've seen, and we actually saw this happening even before things opened up, not only were plaintiffs' lawyers already filing lawsuits, but on the defense side, we were having to deal with, well, what are they claiming? What's the legal theory? What's the statutory basis, or what's the common law basis for the legal claim that they're making? And there's a lot of these, we think, stacked up, and we're going to see more of them. It's just one more way for plaintiffs to get their clients in front of a court and to seek whatever kinds of remedies that they believe their clients are entitled to. What we want to do is to try to help you navigate through this and avoid what I call landmines out there. I've long since, and I didn't come up with the term, but I've long since referred to the employment landscape when it comes to legal issues as being a little like walking through a minefield, because sometimes you don't know what might be right under your feet as you're trying to navigate through. I find in my experience, and now I've been doing some sort of management side, either HR or legal practice for over 35 years, and I find the vast majority of our clients and the vast majority of managers out there are trying very hard to do the right things for the right reasons. They are trying to be fair, and they're trying to comply with the law, but the law has gotten increasingly complex. And as you can imagine, the new COVID legislation and the new scenarios that the whole pandemic and the whole national crisis have spurred have created things that we hadn't thought about before. When I talk to clients, they ask questions that they never thought they would be asking just a few months ago. So there's new scenarios to consider, and that's part of what we're going to try to touch on today to help you think through these issues and to be aware of where there's potential danger, where litigation could crop up, and things you can do to protect yourself and your company. As we mentioned, things have been happening quickly, and that means not only has the law changed, I guess the first statutes passed back in March, and the Families First Coronavirus Relief Act became effective April 1st. Well, now here we are, really mid-July, and not only were those laws new, and did more laws pass after that, but different regulations have come along interpreting those laws, and all of those are guideposts that we have to try to work through as employers to figure out what do we do to comply and to be fair and avoid legal exposure, or at least minimize legal exposure as best we can. Employers are an inviting target for plaintiffs' lawyers, and I don't think that's going to change. So that's just reality in today's world. And the better prepared, the better informed you are, the better you'll be able to deal with it. Lariza, anything that you want to add there?
No, I would just second what you said about some of these government agencies. There was the FFCRA, there were new laws, but also these government agencies are interpreting even what is COVID differently than other government agencies. And how do we react to employees who are positive or not, or what we're even going to categorize COVID as. So every government agency is slightly different in that regard, which makes it harder for employers to decide how to treat, either a case or how to respond to leave requests or things like that. So there's a lot of balancing acts here and a lot of boxes to check when it comes to these government agencies.
And that's one of the things that I find that's interesting and challenging is there are so many different agencies. We've got the Department of Labor, the Internal Revenue Service, the the Occupational Safety and Health Administration. So we've got a lot of different agencies involved in overseeing and administering the various issues that come up under these different scenarios. And sometimes the situations are actually going to fall under the purview of more than one of these agencies. So if it weren't complicated enough trying to just understand the statute and the regulations, now you've got to understand how the different agencies may view the scenarios, and they're pretty fact specific, and that certainly makes it more challenging.
So we'll kind of talk about, is my slide showing up? Okay, great. So we're going to go through some recent litigation topics and issues kind of slide by slide and discuss what we're seeing. And again, you can see this on our litigation tracker, but we're going to discuss the situations that surround these kind of claims. So obviously, when COVID-19 was first kind of affecting our workplace, one of the first things we saw were furloughs, layoffs, RIFs, and other types of, reduced schedule situations happening. And so what this did was create a lot more claims that we weren't seeing before. And this had to do with wrongful terminations. So your typical Title VII wrongful terminations. There's also WARN Act implications. Of course, you need to be an employer that's covered under WARN. There were unemployment claims as well, right? And breach of contract claims, a lot of different types of claims resulted from an employer's furloughs or layoffs, or the way that they handled those types of workforce reductions.
Mm-hmm. One of the issues that came up in some scenarios I've had with employers, Lariza mentioned contracts. There you've got a specific arrangement. It doesn't mean that as the employer that you don't have to comply with Title VII and all the non-discrimination laws that are out there in the workplace. But the contract then also adds restrictions and conditions to the employment relationship. And as business volumes started to plummet, at least for a while, and in some cases they're still way down, companies were trying to figure out, well, what do we do when we have somebody under contract and this is a situation that nobody had contemplated? There's some question as to whether or not the epidemic, the emergency is an act of God. Well, some contracts have force majeure clauses in them that would provide for an act of God, but then the question becomes, does this pandemic, does this crisis actually meet the definition and the recognized world of that kind of an occurrence? So even there, under contracts where you try to lay things out as clearly and specifically as you can, new questions come up, and those haven't been entirely resolved. But certainly, just like you would in any other situation, if you have employees who are under some sort of contract, you obviously need to look at that contract before you change their pay, change their schedule, terminate them. You've got to look and see, what does the contract allow the parties to do and under what circumstances. A couple of other words I wanted to just touch on. Furlough is a word that we hear used a lot, and there's kind of a broad understanding that seems to have developed as to what a furlough actually is and what it means. But I'm not sure that everybody's definition of a furlough is the same. So as you use that term, make sure that you've defined it for your organization. Typically, it means that you've taken someone out of the workplace for some period of time, but you expect that they're going to be returning. That's typically what we see there. And with the furlough, there may be some additional pay or eligibility for benefits or things like that that will stay with that employee, where a person is actually laid off, or if there's call it a reduction in force, employment actually ends, benefits end according to the terms of the benefit plans. That may then trigger COBRA rights for some employees for continuation of coverage, typically medical coverage. So there's a lot of different scenarios that come up. Another thing that you need to think about, Lariza mentioned the WARN Act, which is the federal law that requires employers to give 60 days notice when they're going to do a plant closing or a mass layoff. And there's specific definitions of what qualifies as a plant closing or mass layoff. One thing that's important to remember there is that employees who are furloughed and then later terminated without returning to work may actually be considered under the WARN Act as terminations that occurred back when that furlough started. So let's say that you didn't have enough reductions or enough terminations to require you to provide a WARN Act notice early on when you put some employees on furlough, but later when you determine you couldn't bring them back, maybe that trips the WARN threshold and would require you to comply with WARN. It's a fact-specific analysis, but it's something to think about. You don't want to just forget about whether or not the WARN Act applies. And you have to have at least 100 employees for it to apply, but it's something to think about if you're doing sizable reductions in workforce or doing plant closings. So another point just to keep in mind, when you do reductions in force, there are so many things to look at, because you obviously don't want to ever intentionally discriminate against any protected class. You don't want to act in an unfair manner. But even if you followed all your policies, and this is very important, let's say you have non-discriminatory policies in place and you followed those policies to a T in implementing a reduction in force. But then you step back and you look at that reduction in force, and when you do, you see that, let's just say, for example, 2/3 of the employees who've been reduced are all in a protected age group. But when you look at your overall workforce, maybe only 1/4 of your workforce is in that protected age group. Well, that leads at least to the argument and the potential claim that the way you applied those facially neutral, those facially non-discriminatory policies still resulted in an adverse impact or a disparate impact on that protected age group. And if that's the case, you need to go back and look at it, because you could certainly be the target of a lawsuit alleging age discrimination based on the disparate impact, or it could be on some other criteria. So whenever you're doing reductions in force, it's important not only to go through the process and identify how you arrived at your decisions, how you determined where you were going to make those reductions, but then to step back and just look at your workplace demographics before you started, and then look at your workplace demographics, or at least the demographics of the group that is going to be impacted by the reduction, because you don't want to have an adverse impact or a disparate impact on a protected group of any kind. So it pays you to look at all of those issues. Lariza, anything
Kevin,
else that you would add on this one?
Kevin, we've got a question for you and Lariza. And many of the larger companies here in Houston have people far-flung. Maybe they're on the West Coast, maybe the East Coast, maybe even in foreign countries. If you're laying off divisions or groups or teams, do you bring those people back to their home site? How do you handle the people that you've got on assignment elsewhere?
Yeah. Well, there's a lot of questions, and there's a lot more questions than there are answers. But if you have this far-flung workforce, one of the things that we've heard a lot of companies talk about is sort of reinventing their business and restructuring their businesses, for sure. So there are legal answers and there are practical answers, and you've got to try to find how those can fit together best for your company. But first and foremost, you've got to look at the big picture again. And for example, if there's a particular line of business that you just don't operate anymore, that's going to affect how you decide what your company is going to look like going forward. If there was a service that you provided on site and you've determined as a result of all of this that you no longer are going to be providing it on site, or maybe you don't need nearly as many people to provide it on site, that's going to affect where you need your workers and how they're going to work. Are they going to work from an office, or are they going to be going out to different locations? So I would just say you've really got to evaluate your business. There's not a one-size-fits-all answer. You've got to evaluate your business, what your business needs are going to be now as you're thinking about bringing people back. Because if the business is not going to be the same, and a lot of businesses won't be, and you're not going to have needs for certain positions or staffing in certain areas, that's just a reality. And of course, you've got to be prepared to demonstrate that that is the case, because somewhere along the line, you've also got to anticipate somebody's going to say, oh, no, that's not really the truth. You did this, or you claimed that you had a change in your business circumstances, or that you claimed you had a change in your structure, but this is really pretext for some kind of illegal discrimination. So you've got to always be prepared to show that the changes and the rationale for the changes is real, that it's legitimate. But let's assume that it is, and you have that rationale. Then when you look at what your workforce looks like and what your business looks like, then you start to decide where you're going to deploy your workers, and whether you're going to allow remote work. A lot of companies are going to continue to see a lot of their employees working remotely for a long time, maybe even permanently. So a lot depends on how the company has evolved. So that's a long answer, but the gist of it is there's no one-size-fits-all solution, and it's going to depend a lot on how your business has come through up to this point in the pandemic.
Thank you.
And I would add, as lawyers, Kevin and I always like to say documentation can save you or hurt you. Lack of documentation is worse than documentation. And so when you're making decisions like this, in the present is when you need to be documenting what your decision is and the basis for the decision. A year from now, when you're in a deposition and you're being asked, why did you decide to lay off employee X? You may have a great reason, but if there's something not supporting it, it's just harder. There's no backup for you. So we've been in a similar case together, Kevin and I, where we were trying to find something supporting the reason we gave for a termination, and it wasn't there in documents. And this was later on, months later, and it would have been just so nice if that legitimate reason that we had been documented somewhere at the time the decision was made. And we will discuss best practices later, but I would just include that as we're talking about layoffs and reductions in force, because sometimes having a note to file or some other kind of memo like that can be so helpful in the long run.
That's a really important point. It's always a point that we make, that you need to document, not only because when you can go back to documents that are dated during the time that the decisions were made, it helps support your explanation. But it also, as Larissa said, helps your memory. And just think about this. I know for myself, I like to have things I can go back and look at, because it's hard sometimes to remember what you were doing 3 months ago or 6 months ago or longer. Think about how much harder it is when circumstances are changing as drastically and as frequently as they are now. So for you to try to keep all that straight in your mind without having documentation is going to be even harder, which means the documentation is going to be even more important. That said, make sure that when you do documentation, you think about it, because whether it's an email or something in the file, think about what that would look like at some point in the future if it was up on the wall in a courtroom as an exhibit. You don't want to just fire off a quick email that is the result of maybe momentary frustration. because those things can come back to haunt you. So the documentation needs to be there, but it needs to be thoughtful so that you're not going to later feel like, oh my gosh, I wish nobody had seen that. But think about how documentation absolutely is a tool that can help you not only prove the truth of the information you're providing, but also help you remember all the things that happen, because that's going to be challenging. I know right now, day to day, week to week, month to month, we're all a little disoriented, at least I am, because of just the way work and the workplace has changed. So I think it makes it even more challenging to remember and more important to have things documented.
So there's been a lot of wage and hour litigation already, and there's a lot to go through with this. So first, let's start with furloughs. Another definition of furlough is a reduced schedule, or we'll say reduced schedule. For example, you have exempt employees. A lot of companies or businesses during this unprecedented time have had their exempt employees work a week on and then work a week off. What's important with exempt employees, however, is that even if they work one day on one of their weeks off, they're entitled to that entire week of pay. And so what we're seeing is that, unbeknownst to employers, either they're having exempt employees work during their off week, or they're just simply not tracking their exempt employees, because frankly, they've never really had to do that before. They've tracked their hourly employees, but not really their salaried exempt employees. And so that's one of the areas in wage and hour litigation since COVID that we've seen really increase is wage and hour litigation over your salaried exempt employees, as opposed to your kind of typical hourly non-exempt employees.
A point there that I would just add, Lariza, is that, and I know you've touched on this before, not only are the issues you talked about important, but again, think about the workplace as being reinvented in some ways, and it's changing. So you may have employees who were properly classified as exempt, salaried, they don't get overtime, when all of this craziness began. But it may be that over time, their duties have evolved, and maybe they no longer qualify to be classified as exempt. So that's something else that certainly has cropped up over the last few months. And I'm gonna say something that's very important, very important. I would say this to you before this pandemic broke out. If you looked at all your employees who are exempt, they're salaried, they're not being paid overtime. If you looked at all your employees who are so classified, you would be in the minority. You would be in a small minority if you had all of those employees properly classified as exempt. When those positions are scrutinized by the Department of Labor or by a court because of a lawsuit, you would be very surprised probably at how many times the conclusion is that position should not be classified as exempt from receiving overtime. So now it's even more important to make sure that you have those positions properly classified, and that as things have changed, somebody who was classified as exempt still qualifies to be exempt. And one other point I'll make on wage and hour, and I'll hand it back to Lariza, is this: if you have employees working remotely, accounting for their hours, accounting for their time is a big challenge and something you have to pay a lot of attention to. So you have to make sure there's policies in place, and that the employees know how to record their time, and that they are absolutely supposed to record all work time, because that's another hot button issue in litigation that we're seeing.
So Kevin, a question on not salaried employees, but your hourly, where they're obligated to take breaks and lunch and things like that. If you can't see them, how do you, I mean, must they clock in and out in order to prove that they have taken those breaks and lunch?
I would recommend that they either clock in and out, or that you have some mechanism for them to record their time worked. Most likely there's an electronic way for the employee to clock in and clock out, and the safest way to handle meal periods, especially now where people are working from home or working in unusual circumstances, is to have them clock out and then back in for a meal break. If you assume that there's a half an hour meal break, I guarantee you, and I've seen this happen, think of this scenario. An employee leaves your employment. Maybe you terminated them, maybe they were just unhappy and they leave. And they go see a plaintiff's lawyer. And they go tell the plaintiff's lawyer, I'm so upset, look at how terrible they treated me. Look at how I was wrong. And the plaintiff's lawyer is kind of thinking, I don't know that you really have a case here. But before you leave, tell me how you were paid and how you recorded your time. If you tell that plaintiff's lawyer, the way they handled our meal periods is they just assumed it was 30 minutes. The plaintiff's lawyer's eyes are going to light up because he's going to be thinking that's probably then not going to be accurate, because nobody takes a 30-minute meal period every day. And he's going to light up even more because he says, gosh, and how many employees do you have there? And he's going to be multiplying whatever amount of money he thinks he can recover by the number of hourly employees who are there. So it's a hot button area. It's one that plaintiffs' lawyers like. They can, if they take these cases to court, they can get double damages. So whatever was due, double that number, and they get attorney's fees. That's an area you just have to pay a lot of attention to. So I really recommend that employees clock in and out to start their shift, to take breaks. They may have 3 periods during the day where they're clocked in, but you've got records then showing what time they worked, and you can back up the way you pay the employees. And then you just have to make it clear to them you expect them to record their time accurately.
So another question that we're getting is on the overlap of home and work. So apparently hourly employee has children, and the children come in and either need, a glass of milk or who knows what, or help with schoolwork or whatever. What advice do you give to employers about flexibility and recording when an hourly employee is really working, and can they claim that they're working if they're also doing childcare duty at the same time?
Well, if we had the luxury of employees just being at work, then that would be fairly easy. You work while you're on the clock, and you take care of personal issues when you're not on the clock. When they're at home, you just have to do the best you can to guide your employees and expect them to be honest and fair in the way they record their time. It's difficult, it's a challenge, and one of the things that we think is extremely important is that you not only keep legal issues in mind as you're working through these questions, but that you also keep employee morale, employee relations, and what is it that's consistent about your company? How does your company do things? Because you don't want to demoralize your employees, certainly not in situations like this where everybody's stressed anyway. So I think you've got to work with your employees and try to be as fair as you can. Am I allowed to sit with my child on my knee and help them with their homework while I'm supposed to be working? Well, we'd really rather not see something like that happening, but I think you've got to determine what your culture is and try as best you can to work with your employees to be honest. And you're supposed to be working when you're on the clock. You're supposed to be attending to personal business when you're not on the clock. Do the best you can, and adjust that to fit your company culture.
Thank you.
And I would caution if that's the kind of the stance that an employer wants to take, maybe being more strict in a sense on an employee's time, to ensure that they're doing it across the board. Those kind of claims can lead to a discrimination claim. This employee was being watched more than another employee who was also worked from home and who also had children. So why was employee A being, upheld to some different standard. And I'm not saying they are, I'm just saying that's what their lawyer would argue in those kind of claims. So if that is the position that an employer wants to take to just ensure, if they're doing daily checks on everyone, to make sure it is on everybody, to make sure the rules are being applied to everybody equitably.
That's the voice of experience. We're not just speaking hypothetically. We've both seen that happen.
Another common wage and hour claim that we've seen recently has to do with these bonus hazard payments. A lot of retailers have provided a $2 hourly bonus or some other type of bonus to their employees for working during this pandemic and putting in the hours and serving the public in the way that they are. However, when adding this $2 per hour, that extra $2 needs to be accounted for when calculating overtime. And a lot of employers are just simply forgetting to take into account those extra $2 when calculating overtime. So if you are an employer that has increased your hourly rates or provided that type of extra $2 per hour, ensure that it's reflected in any overtime that the employees are earning and working. I think the last major wage and hour issue we've seen has to do with screenings and temperature checks. There's a question whether, before you're going into work, if you're an employer who's doing temperature checks or other types of screening, whether that time is compensable time. There really hasn't been a decision or an opinion directly on that point, but in looking at prior Supreme Court decisions and opinions, we think, best least risky practice would be to consider that time as compensable. A way to avoid having your employees wait for 30 minutes or 45 minutes or however long they may have to wait, depending how large your workforce is to simply stagger arrival times. There's different ways to go about it in order to save that time. But just be aware that if you're having employees do some type of screening or some extra step before they come into work because of COVID, that may be compensable. Of course, we'll go on to the next one. We've seen a lot of litigation already over the FFCRA, paid sick leave, and emergency family leave. We were shocked that the first lawsuit was filed. The first FFCRA lawsuit was filed before it went into effect. So after it had passed, but before it went into effect, we already had our first lawsuit. And that lawsuit and most of these lawsuits have to do with a denial of leave. So, an employee was requesting paid sick leave, and before she was able to get that paid sick leave, she was terminated. Or frankly, she requested paid sick leave or emergency family leave, he or she, and it was denied. In these kinds of instances, best practice is to be sure that you are providing FFCRA paid sick leave and emergency paid leave as it's set out under the law, and that you are providing it equitably. We have also seen these types of lawsuits coupled with discrimination and retaliation claims. So it's not just FFCRA claims, they're coupled with your Title VII claims as well. And those types of claims have to do with, like I said earlier, employee A was able to take care of her child under the FFCRA, but for some reason, employee B, her request for leave was denied. So you want to make sure when you're granting leave and providing leave under the law that you're doing it equitably. We'll talk a little bit about this in a second, but we've also seen a lot of FFCRA litigation coupled with ADA litigation, so disability claims, and even your traditional FMLA claims. All of these laws are intertwined in these lawsuits already. You have a denial of leave that's not just FFCRA, but perhaps that employee was FMLA eligible, and maybe that employee needed to take care of her spouse or child that had COVID and tried to take FMLA, and maybe it was denied. A lot of times employers are getting confused because because the FFCRA was passed, they think that they don't really need to worry about the FMLA anymore. However, you know, for your knowledge, they're both in play. So every leave request should be looked at and analyzed individually. Look at it from the FFCRA perspective, look at it from the ADA perspective, is this an accommodation? And look at it from the FMLA perspective as well.
If you really, I know you don't want to hear this, but it's true. The FMLA, the Americans with Disabilities Act, and the FFCRA can all be applicable at the same time. So you've got to think about how to comply with all of them.
And just remember as well, Kevin talked about the FLSA damages earlier. Those are the same types of damages that a employee plaintiff can be entitled to under the FFCRA if they are successful in their claims. So the double damages, the attorney's fees. Another important thing to note about the FFCRA, which is actually surprising a lot of employers, is there is no exhaustion requirement. So we've all dealt with charges of discrimination filed with the EEOC or even the TWC, the state agency. But with FFCRA claims, a plaintiff does not need to go through those avenues first. That's why we've seen these lawsuits come so quickly. You know, like I said before the law even went into effect, oh, there was already an FFCRA lawsuit. That's why we expect to keep seeing them as well, because there's no exhaustion requirement. They can be filed the next day. The day after denial of leave, you can, I mean, some employers can expect a lawsuit. So,
and that's also why we're going to see more lawsuits coming down the pipe. We can see them in the pipeline because under Title VII, the non-discrimination laws, the ADA, the employees do have to go through the EEOC and file a charge before they can file a lawsuit. So we're going to see more of that litigation, but they've got to go through the preliminary exhaustion of administrative remedies before they file. So there's a lot of that stuff that's going to be coming. We just haven't seen it reach the lawsuit stage yet. So you've got the initial claims that Lariza talked about that are being filed, and then there's more that are stacking up that can be filed and probably will be filed later.
Right. And we've had a lot of employers kind of think after, you know, school was let out in June or late May that they really wouldn't have to worry about emergency paid leave, and emergency FMLA anymore, because if you'll remember that part of the FFCRA only has to deal with childcare. But as most of you know, camps are being canceled, childcare is being canceled, and now that school's about to start, it's kind of up in the air what's going to happen with schooling as well, with public and private education. So just remember that the FFCRA is the law up through the rest of the year. And it hasn't been extended yet, but until December 31st, this law will apply to you. So just remember that if you get, an EFMLA request because of childcare in the fall semester or even during the summer, that employee may still be entitled to that, even though school was out in June or May.
One of the things that we'll continue to see, and we've obviously seen a lot, you've seen lots of stories in the news probably about workplace safety and concerns that employees have voiced, employees alleging that they didn't have enough safety supplies or enough personal protective equipment. So those are things that are going to be pressed. That means as you look at both of the bullets on this page, there'll also be OSHA complaints, negligence complaints. I mean, there will be any number of different types of complaints, all having to do with workplace safety. One of the things to think about in terms of workplace safety, and the question that's come up a number of times, is should we ask employees to sign some sort of a waiver when they come back to work? And our answer is pretty consistently no, don't do that. For one, employees are entitled to workers' comp insurance and workers' comp coverage under the law. and we shouldn't ask employees to waive that kind of remedy. So just make sure that you think that through. Workers' comp insurance is the exclusive remedy for employees who contract a workplace illness or have a workplace injury. So what does that mean? It means they can't sue you for other things other than if there's an intentional act or there's gross negligence. So you're not going to see those kinds of claims succeed in Texas. Another thing that's unique, though, about Texas is that employers can opt out of workers' comp insurance and go what we refer to as the non-subscriber route. If an employer goes the non-subscriber route, then an employee can make a negligence claim, but that's probably a whole webinar in and unto itself. The key point here is there are going to be lots of claims and lots of questions related to workplace safety. And one of the important things is, one, don't ask employees to waive their rights to be in a safe workplace. OSHA is going to have a problem with that. Workers' comp is going to have a problem with that. There will be any number of issues that would result from something like that. Focus on, for employee relations reasons, and just because it's the right thing to do, focus on maintaining a safe workplace. If you maintain a safe workplace for all purposes, including protection from the COVID-19 virus, then you're going to be better off in the long run, and being able to show and document that you have these workplace safety policies and procedures in place is going to help protect you more than anything else. And let's go on to the next slide, Larissa, and then we may have some questions as we go, but I want to make sure we touch on these. Some other issues that have come up as employers are gathering information through screenings, such as taking temperatures or asking about symptoms. They're collecting medical information. And even though the EEOC has allowed that during these pandemic conditions, employers can perform functions like temperature taking, that's still all confidential medical information. And employers need to make sure they safeguard that information. It doesn't go in the personnel file. Putting it in the personnel file would be a violation of the Americans with Disabilities Act. So you've got to safeguard privacy. Think about what information do you keep. Do you really need to keep records as to what an employee's temperature was, or do you just want to have some sort of a screening where either yes, they had a fever, no, they didn't, and then destroy or otherwise, don't maintain the specific data on those employees, because workplace privacy standards are in play. Let's touch on disability accommodation issues for just a minute. That is probably the hardest issue that most employers deal with day to day, and it's no different now. In the course of the pandemic, there are questions about, I have an employee who claims that they're especially vulnerable. They have an underlying health condition, and they want to be allowed to work remotely. What do I do? Well, if they have an underlying health condition, certainly that if it rises to the level of a disability under the ADA or under state law, which here would essentially be the same thing. If it's a disability, then you have to engage in a process with that employee and determine whether or not there's an accommodation that would be reasonable for that employee. And one of the things that you could consider is whether remote work would be a reasonable accommodation. This is a complex process, and here the process matters as much or maybe even more than the ultimate answer that you determine about what you can do for the employee. You have to go through the process. The EEOC has said, courts have said, there is no one-size-fits-all solution when an employee is seeking or may need an accommodation. It has to be an individualized assessment, and you have to be able to show you went through that process. You didn't just leap to a conclusion. You've got to rely on medical information and objective information, not our opinions as laypersons in the workplace about an employee's underlying condition or what their situation may be. So these are complex issues. In other states like California, oh my goodness, workplace privacy is an even bigger issue, but here in Texas, it's still a big one. Disability accommodation issues are big for everybody. So whether an employee thinks of themselves or says the word disability doesn't matter. What matters is, do they have a condition that would qualify as a disability under the law? And you'd be surprised as to how many conditions do. You've got to walk through these considerations, and you cannot leap to a conclusion. You have to follow that process. And again, I think we may be doing a program on this later on in the year, but for now, just know that this is an involved process and one that you need to work through carefully because it is one that's very challenging for almost every employer I talk to. We mentioned discrimination, harassment, retaliation allegations. That has to do with, how do you administer your policies? Are we even-handed? Are we consistent? Can we show that we've treated everyone the same? But just keep in mind too, the workplace is stressed right now. Everybody's stressed. Everybody's under a lot of different scenarios that they haven't dealt with before, and so sensitivities are going to be higher than they might have been otherwise. So keep that in mind. Maintain good employee relations. You've also still got issues having to do with confidentiality agreements, employees moving between employers. Again, as I mentioned earlier, the potential for class actions or collective actions is there when I talked about the employees and whether they clock in or out for lunch. That's a subject that we see as the basis for collective actions under the Federal Fair Labor Standards Act. So there's a lot of different types of litigation that can arise there. That's just a quick hit on those highlights. Larissa, anything that you want to add to any of those points?
I think the only thing I would add is when we were talking about the ADA and disability discrimination, when it comes to COVID issues, I think it's really important for employers to remember that there are other ways to be liable under the ADA. If you are regarding an employee as having a disability or because of their record of disability, if you're discriminating them or they claim you're discriminating against them on that basis, that can be a real issue. And the reason I wanted to bring that up is because, the EEOC has not come out and said COVID is a disability, and it likely isn't. It's those other underlying issues or the record of having a disability. So that's the only thing I wanted to mention with regard to that.
And even there, COVID is probably not per se a disability, but there are probably situations where it can be. So again, the disability accommodation is a complex situation. We're going to go through a few tips, and we'll go through them fairly quickly because we're running short on time and we'd like to be able to get to another question or two before we wrap up. But what are some things you can do to safeguard your company against litigation? One is continue to make workplace safety and just general compliance with those issues, OSHA, following CDC guidance. Make that a priority and communicate that priority. Make sure that all employees understand that this is task number one, to maintain a safe workplace. And that means ensuring that you have supplies and the things that employees need. Larissa, I'll let you take the next couple of these and we'll
okay.
wrap it up.
Tip number 2, keep training and informing your employees about what you're doing to protect and support them. There was a lawsuit in Dallas about an employee wanting to wear a mask and the employer saying no. The employee won a temporary injunction. So, sometimes listening to your employees and their concerns can go a long way. And communicating with them, like Kevin said, can go a long way as well. Tip number 3, evaluate major employment decisions, especially furloughs, layoffs, and other terminations before implementing them. Like we said before, it's a lot more helpful to have that documented at the time that the decision is made with those legitimate non-discriminatory reasons. whether it's for a layoff or a mass layoff. Also, you can confirm at that time that you're complying with all applicable laws. And of course, if there is a mass layoff or some sort of question, we would recommend that you consult your employment counsel with respect to that.
Just one comment I want to throw in there, and it is that it drives me to distraction when I see policies and I see warnings that talk about immediate termination. Immediate termination under almost any circumstances just makes me cringe, because I've seen so many times that the first facts that get to HR or that get to the decision makers are incomplete and sometimes inaccurate. So rather than quote unquote immediate termination, I have no problem with an immediate suspension and immediately taking the employee out of the workplace while you investigate. But I can't emphasize enough the importance of confirming the key facts before you commit yourself to a termination.
Be aware of the potential claims of retaliation, whistleblowing, or violations of the FFCRA, the ADA, or FMLA. There was another lawsuit, I think in New Jersey, and it was a whistleblower lawsuit, and the claim was that the hospice center wasn't complying with CDC or OSHA recommendations and things like that, and the employee was fired. So that was a whistleblower lawsuit, and it's still being litigated right now. It's public record, you could look it up, but just be aware of all of these different claims and how they can be combined together and work with each other, and how, you know, one fact scenario could implicate 4 different laws. So just be aware of kind of the inner workings of those different laws. Tip 5, pay special attention to employee compensation issues. I think we spent 20 minutes just on wage and hour alone, and we could have probably spent another 45 on them. Now may be a good time to do an internal audit, or kind of just take a look back at how your employees are being paid and how they're being classified, and making any necessary changes now before it may become an issue at a later date. So just be aware with these issues, with bonuses, overtime, and everything we spoke about. Here's the Texas litigation breakdown. We showed you the U.S. earlier. If you go to that map on our website, you can look at Texas specifically, but you'll see that the majority of claims as it relates to COVID are still concerned in discrimination claim within the COVID situation. Final questions.
Boy, there's a lot of good information. Both of you have shared so much good work. So much is changing and so quickly. Where should we direct people to find authoritative information on practice and on law as things are evolving around us? Any suggestions on what where we should be going to keep informed?
The CDC website is really good. The OSHA website is good. They can be a little overwhelming, even a little intimidating sometimes to try to figure out, what does all this mean? But they're pretty good. I'm biased, but our website is pretty good, because what we try to do is we'll take some of those things and distill them down into an article that sort of summarizes the important points. So find a website like that. There may be others that you find are helpful. The Department of Labor put out a list of frequently asked questions. It's pretty good. It has to do with the FFCRA. So there's some resources like that. Larissa, any other thoughts or recommendations?
Always refer to your local authorities as well. And I say that because they're kind of different everywhere and they're changing all the time. So, you know, we're here in Texas and in Harris County region, but just if you have facilities elsewhere, just always be aware of whatever the local authorities have mandated for that specific area.
Yeah.
Well, on behalf of the Return to Work Safely Task Force here in the Tri-County area, Harris, Fort Bend, and Waller, on behalf of the task force members, I'd like to thank you both for an exceptional hour of information. I have to say my head's kind of spinning a little bit with all the things to think about, but you've really given us some very good tips to keep in mind as we go along. For our listeners everywhere, I'd like to remind that we have our website. Our website landing page is Return to Work Task Force, and this presentation and all of the other presentations from our webinar series are listed there, along with a number of other documents and videos that we hope you'll find informational. Our agenda is fourfold: people, medical, both physical and mental health, financial, and strategic. So if there's anything that we can do to enable you, your company, or your employees, please feel free to reach out and let us know. Kevin, Lariza, you guys have just really given us a great hour. And with that, we'll say thank you and wish all of you a good day, a good week, and good health.
Same to you.
Bye now.
Thank you.
Bye.